What can I do if my ex doesn't let my daughter come for my parent time this summer? Our divorce is not finalized, but we already signed it and it'll be soon filed with the court. We have those orders in place for the summer. Well, I can give you my personal opinion, not my legal advice, but my personal opinion from my perspective as a divorce lawyer licensed in Utah and who practices divorce and family law in Utah. You'll need to confer with a lawyer about the specifics of your particular case, but I will give you my general take on the situation. In Utah, if you and your spouse are parties to a pending divorce case, if you and your spouse have made a written agreement governing a parent time schedule at any time during the year, whether it be when school is in session or when school is dismissed for the summer, if you have an agreement, but the terms of the agreement have not been made the order of the court yet, if you are upholding your end of the agreement, you're complying with all of the terms of the agreement. If the date when school will be dismissed for the summer is in just a few weeks or even just a few days, then if your spouse tries to renege on the agreement and tells you that he or she won't comply with the agreement, I would then immediately and without delay file an ex parte motion for a temporary order, perhaps an ex parte motion for a temporary restraining order, or TRO, and that would be asking the court to order the parties to adhere to their parent time schedule agreement and request expedited disposition of that motion. The longer you wait, the harder it is to prevail in a situation like this. You can request that such a motion be reviewed and decided by the court much more quickly than a typical motion if you can show that time is of the essence, meaning that unless the motion is decided immediately, you will suffer the adverse effects of your spouse's non-compliance with your parent time agreement. You can argue that unless the court upholds and enforces the agreement, both you and the children will suffer irreparable harm. See Utah Rules of Civil Procedure, Rule 65A for more details. While there are no guarantees the court would grant such a motion, every judge sees things his or her own way, your odds of succeeding on such a motion are, on the face of it, pretty good.